Committee. So we are really excited to have Wilson Turner Kosmo here with us. WTK has been a longtime supporter and sponsor for the ACC San Diego chapter, and their annual employment law forecasts are really immeasurably helpful as we as employers try to gauge what's next in the ever-changing landscape in California. So we're very excited for us to have with us today Tia Butler and Katie McCray. Katie McCray is a partner in the firm's litigation and business litigation practices. She's handled all matters of all sizes and complexity, both in the business litigation realm and the employment lit realm, and employment litigation representing employers in single plaintiff all the way to large scale class action litigation. So really glad to have her with us today. Also, we have Tia Butler, who is a senior associate, also practicing both in the business litigation and employment lit groups at Wilson Turner. And she's handled individual, class, representative, collective actions across the board and managed all stages of litigation, even all the way through trial and arbitration. So really grateful to have you both with us today, and I'll turn it over to you both.
Thank you so much, Hannah. Welcome, everyone. We're excited to have you join us for an overview of what's going on in the California legislature, up to the moment update. As always, there are a lot of things that may affect employers in the coming year. So I'm going to go ahead and share my screen so you can see we've prepared some slides with some information for you today. Hannah has already introduced us. You'll see we've included our contact information here. I'm going to invite you to ask any questions you may have during our presentation today. If you have a question while we're speaking, please feel free to drop it into the Zoom chat. We will do our best to either address it in the context of our presentation or save it for the end. We'll have a few minutes for Q&A. Or if you want to save your question for the end, you can feel free to take yourself off mute and speak up when we get to that question portion. Or if a question occurs to you after the presentation today, please feel free to reach out to either of us directly. So here's our sort of very brief agenda. Today, we're going to briefly outline a few new laws that have already gone into effect. Hopefully you have heard about them, but we'll give you a quick overview. Then we're going to spend the majority of our time today talking about bills that are currently pending in the California legislature. And at the end of our presentation, we'll give you a quick summary of some key employment-related bills that have stalled for the year, because those can always come back later. And I think it can be helpful to know sort of where we stand in the California legislative process. California is, I don't know if it's unique, but among states, but it has a set of deadlines for the introduction and passage of new laws each year. And so we have just passed a key deadline, which was the deadline for the deadline for bills to be voted on by their chamber of origin. So if a bill was introduced in the assembly and the assembly hasn't voted to approve that bill, it's dead for the year. However, all of the bills that are currently pending have been passed by either the assembly or the Senate. While bills can still be amended, they could change. And while we don't have any guarantee that the bill is going to be passed by the other group and then signed by the governor, we do have a sense that these bills that we're going to talk about today have some measure of support. They've already passed one of the bodies of the legislature. And then one other thing I just wanted to note is that even though there are these deadlines in California, it is always possible to be surprised. There are ways to work around these deadlines, and legislators do on occasion find ways to work around these deadlines. Just as an example, I'm sure you guys have all heard about the Supreme Court's decision yesterday regarding the arbitration of PAGA claims. Now, we're not going to talk about that in detail today, but I did want to point out that at least one California senator, who is the chair of the Labor and Employment Committee in the California Senate, has already started talking about legislative action to respond to that Supreme Court decision and to preserve PAGA representative actions. So we're closely watching for any last minute attempts to amend PAGA. We'll keep everyone who follows the WTK legislative updates will keep you informed. It is possible to be surprised. But the next big major deadline is August 31st. That's the deadline to send bills to the governor for signature. We're going to continue to monitor these. And if you're not signed up for our legislative alerts, we'll share some information at the end of our presentation about how you can do that and get our continued ongoing updates on monitoring all of these bills. Then before diving in, we also wanted to give a little bit of an overview of the California outlook. I don't think this will come as a surprise to anyone, but there's continued one-party rule in Sacramento. There are sizable, and this year increased supermajorities in both legislative chambers for the Democratic Party, and Governor Newsom, of course, is from the same party. Last year and in 2020, there were approximately 25 new laws bearing on employers. And this was despite some procedural limits that were imposed on the number of bills the legislature considered because of COVID. This year, those limits are raised, and there's a very busy agenda in Sacramento. Lots of bills that carried over from 2021 and also new 2022 bills. However, sort of as a countervailing indicator, two powerful legislators who have been very involved in employment litigation retired as of last year. That's Senator Hannah Beth Jackson and Assemblymember Lorena Gonzalez. And so there's been a little bit of a fall off in employment related bills because those two powerful legislators are no longer active. So with that in mind, I'm going to turn it over to Tia to talk a little bit about some of the new laws that have already passed.
Good afternoon, everybody. Like Katie said, we're going to go ahead and get started with the new laws. I am not going to give you guys a pop quiz to make sure you've already implemented these, but if anything stands out here as we go over the next 4 or 5 slides, you'll definitely want to revisit the slides after the fact, make sure you've covered your bases here. So starting off, we are going to talk about the limitations on mandatory arbitration of sexual assault and sexual harassment claims. This was signed into law on March 3rd, 2022 by President Biden and went into effect immediately. It's known as the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. This law amends the Federal Arbitration Act to prohibit enforcement of any pre-dispute agreements related to sexual assault or sexual harassment disputes if the victim chooses to file in court. And that is the kicker to this law. Some people originally thought that arbitration was prohibited by this act, and that is definitely not the case. What this law does is it merely puts it back into the alleged victim's hands to choose whether they want to proceed in arbitration under any pre-existing agreement, or if they want to try their hand in court. The next law that we're going to talk about are the COVID-related supplemental paid sick leave laws. And that's SB 114, which largely reenacted the prior COVID-19 supplemental paid sick leave law, which was SB 95. That expired in September. So this law took effect February 19th of 2022, but it was retroactive to January 1st, and it is effective until the end of September this year. Again, in large part, this reenacted what was already in place. There are some nuances, but the big stuff you want to be mindful here is that employers with 26 or more employees are required to provide up to 80 hours of paid sick leave to full-time employees. And that 80 hours is broken down basically into 2 different buckets of time, all of which is related to COVID. So the employer is required to provide up to 40 hours if an employee is unable to work or telework for a myriad of reasons related to COVID. If they are attending to a booster, getting a vaccine, if they are quarantining or isolating because they're experiencing symptoms, if a child who they care for, their school is closed down because of COVID, and it also applies to family members in their household. So that's that first 40 hours. The second 40 hours of the up to 80 applies if somebody, whether the employee, the family member, or the child actually tests positive for COVID. As is implied by the name, this is supplemental to the sick leave that employers are already required to provide for employees under Labor Code 246. Also important to note with this law, employers may not require an employee to use other leave, PTO, vacation that they may have in lieu of applying this time. Again, the law is really intended to make sure that those impacted by COVID have that leave available to them for this specific purpose. There are a bunch of other requirements under the law that are minor, but the Labor Commissioner did set up a FAQ section that's pretty helpful. So if you have questions about this, you can certainly go on to the Labor Commissioner's website and find additional information about employers' rights to request documentation from employees who may be seeking to utilize this leave, the rates that should be applied to the sick leave, wage statement requirements, and then also the notice requirements under this law. Moving right along, one that is of utmost importance to all of our employers, SB 3. SB 3 relates to minimum wage, and this was enacted back in 2016, and that set into motion a series of wage increases that were to go into place over time. At present, the larger employers, those with 26 or more employees, have minimum wage at $15 an hour. Those with 25 or fewer employees are at $14 an hour, and those smaller employees were slated to the employers with 25 or fewer were slated to have those minimum wage increases go up to $15 an hour on January 1st of 2023. However, SB 3 had built in certain provisions that required additional increases if the CPI exceeded certain enumerated levels, and that happened over the last year. As a result, effective January 1st, 2023, minimum wage is going up to $15.50 an hour for all employers, regardless of size. Importantly, that not only impacts the hourly minimum wage, but it does factor into the salary threshold for exempt employees. That threshold is going up to $64,480 annually, or $5,737.33 a month. That salary exempt threshold requirement is something that employers can sometimes overlook when there is a minimum wage increase that goes into effect. So it's important just to be sure anytime you see a minimum wage increase for hourly employees that you're also making sure your team is checking those salaried employees, their pay scales, and making sure that the proper attendant increases are made if necessary. This did not make it onto the slide, but I just want to pause real quick and make you guys aware of another ballot initiative that is on the horizon. Signatures are being gathered for what would be another potential minimum wage increase. The proponents are trying to get it on the November ballot, and it would require or would set into motion another series of increases with the top minimum wage being $18 an hour. Much like SB 3, that would be phased over time, starting with the higher increases for the larger employees and then the smaller employers coming up down the line. But we'll keep an eye on that and see how it goes. Again, keep your eyes and ears open, and we'll see. Next up. Okay, so we have another one. I don't know if we have any employers on the line that have a large enough constituency of San Francisco-based employees, but I did want to take a minute just to at least put this on your radar because it does have some pretty serious implications. The San Francisco Family Friendly Workplace Ordinance was recently amended, and it was amended to have more teeth, more enforcement, more rights for employees. Previously, employees had the right to ask for flex or predictable work schedules, but there wasn't much there. There wasn't much teeth to it. Nothing they could really do to require an employer to follow through. The amendments that took place require employers that fall within the ordinance to actually, once an employee requests the flex schedule in order to provide care to somebody in their family, whether that's a child or a family member or a parent who's 65 or older, requires that they actually sit down with them, meet with the employee within 21 days of the employee making that request, And it's really kind of an ADA type interactive process that you have to engage in. Now, 21 days after that meeting takes place, the employer is then required to provide written notice to the employee of the decision that was made. And if the employer is denying that request for the flex schedule or the predictable schedule, they have to put in that notice a bona fide business reason as to why they're denying the request. And that really falls within the undue hardship to the business. That's really the only reason you can put in there. Another thing that has to be included in that notice is a right to the employee of their opportunity to request a reconsideration. Really quickly, the covered employees, they have to be employed in San Francisco or telecommute out of San Francisco. They have to be employed at least 6 months by that same employer, and they have to work a minimum of 8 hours per week. I think that covers the highlights of that one. Again, it's pretty nuanced, but I wanted to make sure you guys had that on your radar. With that, I'm going to kick it back over to Katie, who's going to talk about some of the pending bills.
Super. So we're going to sort of break down the pending bills into a couple of general categories of topics. And we're going to start with some bills that are relevant to harassment, discrimination, and retaliation. So you guys may have heard of California's Unruh Civil Rights Act, which already prohibits business establishments from discriminating based on specified characteristics. So businesses can't withhold services or deny accommodations to their customers on the basis of a protected characteristic. This new bill, AB 2448, arose from concerns about increased bias-based harassment of the public, particularly against Asians and Asian Americans following the pandemic. So AB 2448 would apply to private businesses with a physical presence in California that are open to the public and have 100 or more employees in California. So this doesn't apply to small businesses, have to have at least 100 employees in California. And then it would require those businesses to address harassment of customers on their premises, whether by the business's employees or third parties. And it's notable, I think, that some of the definitions, premises means either inside the building or outside areas if those areas are under business management or control. So it could include places like the parking lot. And harassment is defined as words, gestures, or actions directed at a specific person because of a protected characteristic. So this is slightly different from and a lesser standard than under FEHA, which, as I'm sure you know, requires severe and pervasive action to rise to the level of harassment. Now, what do covered businesses have to do? They're going to have to post a sign that the DFEH is going to create, which notifies customers of their rights and how to report harassment. They have to train employees, which we're going to talk about in a moment on the next slide. And they need to create a policy about the collection and maintenance of data about third-party harassment, and then provide that data to the DFEH upon request. Now, notably, there's no obligation in the current bill to affirmatively intervene if there's harassment. However, a business can't retaliate against employees for taking any actions pursuant to these requirements. So it's an interesting thing that businesses are, fine line businesses are being asked to walk. But then sort of one of the most concrete requirements for employers is that if this bill passes by January 1st, 2025, covered businesses are going to be required to provide bias-based training to their employees. The DFEH will develop the training. It's going to be at least an hour, but not longer than 2 hours. There won't be a distinction between supervisory and non-supervisory employees the way there is for sexual harassment training. Same training for all employees. And that training is going to have to be provided within 6 months of hire or promotion, unless the employee has received timely training from a preceding employer. And then there's going to have to be refresher training every 2 years, again, if this passes. The next bill we wanted to talk about is AB 2777, which is entitled the Sexual Abuse and Cover-Up Accountability Act. It addresses some concerns that victims of sexual assault may need additional time to pursue legal claims by modifying the statute of limitations for certain claims. So AB 2777 would revive some claims related to sexual assault or other inappropriate conduct of a sexual nature if those claims were time barred as of January 1st, 2023. So in order to be able to revive a claim that's already barred by the statute of limitations, the plaintiff would have to show that they were sexually assaulted or subjected to other inappropriate conduct, communication, or activity of a sexual nature. They have to show that one or more entities are legally responsible for their resulting damages, and that those entities, that entity or entities engaged in or attempted to cover up a previous instance of sexual assault or other inappropriate conduct by an alleged perpetrator of abuse. Now, what's really notable here is that cover up is defined to mean an effort to hide evidence of inappropriate conduct of a sexual nature that incentivizes people to remain silent or prevents information from being made public or disclosed to the plaintiffs. And it explicitly includes the use of non-disclosure or confidentiality agreements. Now, also notable is that the way I read this, the cover-up could be completely unrelated, could be on a completely unrelated claim by a completely unrelated perpetrator. It's not that the employer tried to cover up this plaintiff's claim, or that they tried to cover up something related to the plaintiff's alleged perpetrator. Arguably, it could, anytime a company entered into a confidential settlement of any prior claim related to sexual misconduct, that could constitute a cover-up as defined by this bill, which would allow any plaintiff with a claim that satisfies the other requirements of the statute to revive a time-barred claim. So it has potentially, I think, broad implications if this passes. Also, notably, the revival of these time-barred claims would apply to related claims, including sexual harassment and wrongful termination, unless those claims had already been settled or resolved in court prior to January 1st, 2023. There is a limited window in which to bring these revived claims under the bill as it's currently drafted. It'd have to be brought between January 1st and December 1st, or December 31st, 2023. But there's no limit on the age of claims that could be revived. I mean, arguably, someone could bring a claim from 10, 15, 20 years ago under the bill if it passes. The next bill we wanted to talk about changes how employers can use marijuana tests, essentially. So this bill addresses concerns that some employer drug testing focuses on the presence of some so-called non-psychoactive cannabis metabolites that don't actually indicate impairment at work, as opposed to simply revealing that an employee may have smoked marijuana at some point away from the workplace. So it's intended to encourage employers to rely more on testing for tetrahydrocannabinol, or THC, which measures active impairment or psychoactive effects. So with that sort of background in mind, the bill would amend the FEHA to preclude employers from discriminating against employees or applicants based on cannabis usage away from work or a drug screening test which reveals non-psychoactive cannabis metabolites. Notably, the bill would not preclude pre-employment drug screening that's not screening for those non-psychoactive cannabis metabolites, it's screening for something else like THC. It also does not preclude performance-based impairment testing or corrective action if the employee is actually impaired on the work site during employment hours. And it doesn't preclude testing for the active presence of THC on the work site during employment hours. It wouldn't preclude THC testing or screening if federal law requires it, or if the employer would lose money or licensing benefits unless it tests. And it's not applicable to the building and construction industries or to jobs that require a security clearance. So a lot of exceptions, but in general, they're trying to push employers away from testing for just having smoked marijuana and towards this testing for THC. SB 1044 responds to media reports of employees who were killed or injured during recent natural disasters, such as the warehouse employees who were affected during the December 2021 tornado outbreak, or domestic workers who were forced to work during California's wildfire outbreaks. So this bill would preclude employers from taking adverse action against employees who refuse to come to work or who leave work if they feel unsafe. Would also preclude employers from preventing employees from accessing their phones or communication devices to seek emergency assistance, assess safety, or communicate to verify safety. Now, this applies only in certain defined states of emergency or emergency conditions. A state of emergency is defined as a time when the place where the worker lives or works is facing an imminent risk of harm based on a presidential declaration of disaster by natural forces, a declared state of emergency, a federal or state regional alert of imminent threat due to natural disaster, but it's specifically defined not to include a health pandemic. And then an emergency condition is a disaster or extreme peril to the safety of persons or property at the worksite caused by natural forces or criminal acts, or an evacuation order of the workplace or the employee's home or the place where their child is. So specifically defined to apply only to emergency conditions that pose imminent risk of harm and not to emergency conditions that remain in place for a long time, like the COVID-19 type restrictions. As is typical in this type of bill, it would require a notice by the worker if they're not going to show up at work or if they're leaving work, if that's feasible. And there's a long list of employees for whom this bill would not apply, including first responders, disaster service workers, healthcare workers, utility workers, and more. And then responding to some employer concerns about potential PAGA actions, the bill as it is drafted right now specifies that employers have the right to cure alleged violations pursuant to Labor Code Section 2699.3. All right, I'm going to turn it over to Tia to talk about some human resources and workplace policies.
All right, folks, we are about to embark upon the ever so exciting area of data reporting, background checks, and settlement agreements. Let's see. Starting with the SB 1162, this really falls into two different categories. Okay, so this affects pay scale reporting and pay data reporting. Pay equity concerns have been a primary legislative focus recently, and this law updates several recently enacted laws regarding pay scales and pay data. Again, there are multiple parts to this, so I'm going to break it up to make sense into that pay scale stuff and then followed by the data reporting. Currently, employers are required to provide pay scale information to an applicant after they've completed their initial interview. In context of SB 1162, pay scale just means the hourly rate or salary that applies to the position. So that's where things currently stand. After initial interview, they're required to provide it. This bill would require employers of 15 or more employees to provide pay scale in the job posting, and that applies if the employer is directly posting the position or if they're going through some third-party agency. Additionally, it would require employers to give pay scale data to employees that are currently in position if they make a request for that information. And it also requires employers to maintain copies of the job postings as well as wage rate history for their employees throughout the duration of their employment and an additional 3 years after the fact. These records that employers would be required to maintain would be subject to review by the Labor Commissioner. Additionally, as we often see is the case, it provides for new civil penalties for failure to comply. And importantly, it creates a rebuttable presumption in the employee's favor if the employer fails to maintain these records. So that's hugely important that if this does come into play, you guys are watching the maintenance of those records. Following on what Katie just said, and as is a constant concern of ours representing our clients, there are concerns about PAGA, of course. So this bill would allow employers an opportunity to cure any PAGA violations after they receive notice. And the bill specifically outlines what methods would be available to cure that violation depending upon what that violation is. So that's the first part of 1162. And we're going to move on to the data reporting components. So enacted in 2020, SB 973 required private employers with 100 or more employees to file an employer information report. That's an EEO1 pursuant to federal law. And they had to submit pay data report to the DFEH, which included the number of employees broken down by race, ethnicity, sex, based upon the specified job categories. Employers could comply with the DFEH requirements by merely submitting that same EEO-1 that was required under federal law. 1162 would require a separate pay data report for employees hired through labor contractors, including disclosure of the labor contractor ownership. The impetus behind this is they're trying to, or they say they're trying to increase the data that's collected with regard to the pay equity issues. The argument is that some employers are circumventing the law by failing to disclose contractors because it is currently specifically limited only to disclosure of employees. So theoretically, this would help with gathering that data. Additional changes under the bill would require employers to provide median and mean hourly rates for each combination of race, ethnicity, and sex. Very importantly, the EEO-1 would no longer be allowed to be submitted to comply with the law. The DFEH would also be required to publish this data. This is critical because initially publication of the data was shot down, and now it's back in play where there would be a publicly available site where this information would be available for everyone's review. Again, it provides for new civil penalties for the failure to comply, and it also would provide for a change in the reporting deadline, which is currently March 31st, and that would be moved to the second Wednesday of May every year. Briefly on the aspect of publication, if the publication does go into effect, that would start in 2025 with employers with 1,000 or more employees, then move to those with 500 employees for 2026, and so on. Specifically, no private information would be disclosed. And in response to employer concern that the data may be taken out of context and may not provide the whole picture, if this does go into that public realm of publication on some website, there is going to be something put into place where employers do have an opportunity to submit additional data that they would like people to take consideration of, and that would somehow be factored into that publication. Next up, we have an easy one. This one is a good old common sense potential law, SB 1262. This relates to background checks, and background check companies typically use an individual's date of birth or their driver's license number when performing background checks through court records. The very obvious reason is they want to be able to have something to cross-check names with in case there's a typical name and they don't want to get those false positives. However, there was a recent California appellate court decision, which is All of Us or None of Us v. Hamrick, that came down in 2021. And the court held that a specific California rule of court precluded electronic access to this sort of information. So in response to the concerns that the interpretation of that decision would complicate background checks and potentially lead to unverifiable false hits for those folks with common names, this bill specifically authorizes searches and filtering of publicly accessible court records based on the criminal defendant's driver's license number, date of birth, or both. Next, we're going to talk about limits on confidentiality agreements. And at present, as I'm pretty sure you all know, California law prohibits settlement agreements from containing confidentiality provisions that prevent disclosure of factual information related to certain claims. Most commonly, that comes up in our context in the case of harassment claims. So kind of as an extension of that, SB 1149 would prohibit confidentiality in agreements related to claims or damages on a defective product or environmental hazard that poses a danger to public health or safety. And that is a product or condition that has caused or is likely to cause significant or substantial bodily injury or illness or death. This probably doesn't come into play in many of our employment disputes as an obvious factor, but there certainly are some public safety instances that come up in employment claims. And so this is something you guys will want to have on your radar. And it especially strikes me because of the ambiguity of the language. And in the settlement context, I can see it being quite difficult to determine whether something that touches upon public safety really falls within this broad definition and would be subject to these confidentiality prohibitions. Noteworthy, and I'm sure your attorneys will be very on top of this one, the bill provides that an attorney's failure to comply with these provisions is grounds for professional discipline. Also noteworthy, any person, including a representative of the media, can challenge any provision that restricts disclosure of covered information. So it really expands the realm of those that can get their, get their fingers in the mix. And with that, I am going to kick it back over to Katie to touch upon the pending bills on leaves of absence.
Super. So this year, believe it or not, there's only one significant bill regarding a leave of absence that's still pending. And an emerging criticism of the California Family Rights Act and the Family Medical Leave Act is that they provide time off to care for a seriously ill family member, but do not provide time off to the employee in the event that the family member passes away. So this bill would require employers to provide up to 5 days of bereavement leave following the death of a family member. And that's defined to be a spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. This law, if passed, would apply to private employers with 5 or more employees, so almost everyone. And employees would be eligible for this leave after 30 days of employment. Now, employees need not take all 5 days consecutively, but all of the leave must be completed within 30 days of the family member's death. The bill provides for unpaid leave, but employees could use other paid time off if they had any available. And if an employer has an existing bereavement leave policy, the employees would be entitled to additional time off to reach that 5-day minimum. And then finally, the bill does allow employers to request documentation such as an obituary to justify the time off. Because this new right would be codified in a new section of the government code right next to the California Family Rights Act, employees who believe they may have been discriminated against or retaliated against or denied this available time off would presumably be entitled to the same rights and remedies available for violations of the CFRA and or FEHA. However, we think that alleged violations of this new section against smaller employers, that is those with between 5 and 19 employees, would be subject to the recently created mediation pilot program for CFRA claims against smaller employees. I see a question asking if miscarriage is counted in a child. I do not know. I'm sorry, I don't know the answer to that question. It is certainly not specified that this leave would apply to miscarriage, but I am certainly happy to look into that and get back to you if I can find a specific answer. My guess is no, it does not apply to that, but we can certainly follow up to confirm that. So somewhat shockingly, there's also only one wage and hour bill that we wanted to highlight this year. And this one is specific to an industry, but I think it's really interesting. And so if this applies to you, definitely, and your business, definitely want to be tracking it. This new bill would apply to fast food restaurants. And that's defined in the bill to be part of a set of restaurants containing at least 30 or more establishments nationally that share a common brand or standards, and that primarily provides food or beverages in disposable containers for immediate consumption. With limited to no table service. This bill would establish a fast food sector council, which would establish minimum standards on wages, working hours, and other working conditions regarding health and safety in these restaurants. Notably, it would also require franchisors to ensure that franchisees comply with a variety of employment, worker, and public health and safety laws and orders in California. It would then impose joint and several liability on franchisors and franchisees for violations of any of those laws. And it would explicitly provide that the laws could be enforced against a franchisor to the same extent that they may be enforced against a franchisee. And the bill would prohibit a franchisee from waiving this provision or agreeing to indemnify its franchisor for this liability. Finally, this new bill would create new retaliation protections for fast food workers who make complaints about or disclose information about public health and safety, or who refuse to perform work because they believe that the fast food restaurant would violate worker or public health and safety laws or pose a risk to the health and safety of employees or the public. The bill would create a presumption of retaliation for actions which are taken against an employee within 90 days of any of this protected activity, and it would establish treble damages for any violation of these new retaliation provisions. So if this is your industry, definitely keep an eye on this one. Tia, tell us what's going on with COVID-19 still.
Still, we're sprinkling COVID-19 throughout this. So these are actually pretty easy ones to cover. We've got two to talk about here. AB 635 was enacted a while back, and that required employers who receive notice of potential exposure to COVID-19 to provide certain notices within 1 business day. And under the certain circumstances, they may also have to provide separate notices to health agencies within 48 hours. AB 635 also provided some additional powers to Cal OSHA, who could prohibit employer access to and usage of portions of a work site that may constitute an imminent hazard to employees due to potential COVID-19 exposure. That is set to expire January 1st, 2023. AB 2693 would merely extend the requirements of that law through January 1st, 2025. With no notable changes. Also in 2020, California created a rebuttable presumption for workers' compensation coverage for employees who contracted COVID-related illnesses under certain circumstances. And AB 1751 would again extend that law with no notable changes through January 1st, 2025. So nothing really new to note. Just make sure you continue to implement what's already been enacted if that passes. And kicking it back over.
Thank you, Tia. I don't know that any of this has been particularly interesting, but I'm not sure that this next section is a little bit dry, but we're going to highlight it for you. Nevertheless, some proposed changes regarding state-provided benefits like workers' compensation and unemployment insurance. All right, so the first bill that's pending is SB 951, which would increase weekly paid family leave benefits by the state disability fund from 60% to up to 90% of wages, subject to certain caps, and there are incredibly complicated calculations for people who make different amounts of money. But the idea would be to increase those paid family leave benefits beginning January 1st, 2025. This would also remove a limitation on workers' compensation contributions to the Unemployment Compensation Disability Fund. Next, SB 213 would change workers' compensation coverage for hospital employees providing direct patient care in acute hospitals. It would define injury for workers' compensation purposes to explicitly include this list of conditions, including infectious diseases, cancer, and COVID-19. The bill would also create a rebuttable presumption that these injuries arose out of the course and scope of employment for purposes of the workers' compensation determination. AB 2847 is a proposed pilot program regarding providing unemployment assistance for undocumented workers. So workers who currently are excluded from federal or state unemployment benefits could be eligible for benefits under this new bill. It would apply to individuals who reside in California and who performed a defined amount of work in California over the prior 12 months. And it's not a lot. It's not a lot of hours that is required to fall within the coverage of this new bill. It would provide $300 per week for each week of unemployment between January 1st, 2024 and December 31st, 2024, up to a maximum of 20 weeks. So again, it is a pilot program set to apply if it passes for only 1 year, and presumably the legislature would then assess whether they wanted to continue it. Notably, it would require a separate appropriation by the legislature of sufficient funds to carry out the program. So certainly not something that directly will hit the pocketbooks of businesses, but indirectly, it will affect all of us if this passes. Next, there is a proposal to expand the meaning of medical treatment under the workers' compensation law to include the services of licensed clinical social workers and to authorize medical provider networks under workers' comp to add LCSWs as providers. Let's see what's next. These would be more changes to workers' compensation for a specified set of workers. So this bill would apply to certain law enforcement or first responders. First, it would reduce the period of time an employer has to reject liability for a workers' comp claim for those employees from 90 days to 75 days. It would increase the number of compensable weeks from 104 up to 240. And it would increase the penalty for unreasonably rejecting specified claims for law enforcement or first responders. So that was my very quick summary of the always exciting area of state provided benefits. And Tia is going to clean us up with a couple of miscellaneous bills.
Funny you should use that terminology, cleaning up. We're talking about bathrooms next, folks. We have AB 1632, and this involves public access to employee-only restrooms. Since 2005, 17 states have passed laws requiring businesses to allow members of the public experiencing medical emergencies to use employee-only restrooms. AB 1632 is California's response to that and puts into place would put into place a similar law. If enacted, places of business that are open to the public for the sale of goods that have a toilet facility for their employees to use would need to allow certain individuals who are lawfully on the premises use of that facility during business hours, even if they don't normally offer that to the public. All of the certain criteria need to be met. The individual has to have an eligible medical condition such as Crohn's disease, IBS, and so on, or use an ostomy device. 3 or more employees must be present on site. Permitting use of the facility could not create an obvious health, safety, or security risk. And the public restroom, a separate public restroom is not otherwise available. Businesses under this bill may require reasonable evidence of the medical condition or ostomy bag usage. I can't imagine somebody wanting to press hard on that issue, but just know that is available should you choose to want to enforce it under the act and it comes into effect. Next up, we have new lease disclosure requirements regarding parking. This is kind of a complicated one, but does impact employer requirements, so I'll spend a brief minute on it. This bill would require employers with 50 or more employees who are in air basins designated as non-attainment areas who already provide parking subsidies to its employees to take certain action. Non-attainment areas, for those that aren't familiar with the term, basically that just means it's in a location where the area has too much of one of the nation's most widespread or dangerous air pollutants. The designations are made by the state board annually. Last I checked, San Diego was not on that list. LA and Riverside are, so they're in relative close proximity, which may come up in your, potentially come up with your employees. Basically, this currently in place, there is something that requires employers that fall within this category. If they already have a parking subsidy for their employees, they are required to provide a cash out program where if somebody wants to take public transit, they can cash in their parking spot and get some sort of an allotment. The difficulty with enforcement of this, and the reason this bill came into play, is that most leases have parking costs bundled with the lease. So there's not a separate delineated line item that employers could use to determine what that cash out value should be. So to combat the problems with implementation and enforcement of this law, this new law would require lessors of new or renewed leases to include a parking line item separately in the lease. And if it's not in the lease itself, it gives them 30 days to actually provide the lessee with that information. Importantly, even if the lessor does not do what they're supposed to do, this law would put the onus on the employer to still provide some sort of a cash out program. So they can no longer say, it's not in my lease, I don't have to comply with it. Employers would also be required to provide that parking cost information to its employees upon request. Next up, I am going to fly through this because I know we're running short on time, and this is another area that's really in flux right now. We have the FEHC has published some draft regulations regarding artificial intelligence machine learning that would prohibit the use of automated decision systems, known as ADSs, that screen out applicants, employees, or classes based on protected characteristics unless job-related and consistent with business necessity. This is still in the very preliminary phases, and even after it goes through the first round, it's going to go out for public comment. There's a ton of ambiguity, and this all needs to be fleshed out. But I think probably for our purposes here today, the quickest thing that I can do is just give you some examples that I think may resonate and help you see how this may play out. An example of an automated decision system that measures an applicant's reaction time may unlawfully screen out individuals with certain disabilities. So unless an affirmative defense applies, such as the employer can demonstrate that a quick reaction time while using an electronic device is consistent with the business necessity, screening by this basis may give rise to an unlawful discrimination action. Another example is, an automated decision system that analyzes an applicant's tone or facial expressions during a video recorded interview may unlawfully screen out individuals based on race, national origin, gender, or a number of other protected characteristics. Again, unless there's affirmative defense that applies, that may constitute unlawful discrimination. For now, just be mindful that any automated decision system that's used in connection with your employment making decisions, you want to have your eyes on that. You want to strive not just to take the results at face value, but in anticipation of regulations and laws coming down the line in this regard, you really want to hone in on what the results are used for, what algorithms are being implemented, how those decisions are being made, because you may be called to task to really, put thought to that down the line. I'll go ahead and turn it back over to you, Katie, for the industry-specific bills.
Thank you. So we wanted to just mention a few bills that are relevant only to pretty narrow industries. And I'm just going to mention these briefly. Obviously, if any of these are applicable to your business, you may want to investigate further, and I'd be happy to discuss further if you want to reach out offline. But first, there's a proposed expansion of the list of businesses who are required to post human trafficking notices to include businesses providing hair, nail, and skincare. Next, there are some new rules regarding workplace safety for entities that contract with an entertainment venue vendor to set up, produce, and tear down live events at public event spaces. Potentially slightly broader implication, there are some further proposed changes to garment manufacturing, joint and several liability. There have been several recent changes in this space for various entities involved in garment manufacturing processes. And there's a bill that would further clarify or expand the joint and several liability for those entities in that business. Next, and I'm not sure if this is applicable to anyone on the call, but there's a proposed expansion of meal and rest period requirements to employees of public hospitals, essentially taking the meal and rest period requirements that are applicable in private businesses and applying them to employees of public hospitals. Next, a few that are potentially applicable to the agricultural industry. There are some proposed changes to the final pay rules for seasonal employees in certain agricultural industries that would reduce the period in which final wages must be paid after a layoff of those seasonal workers. So if that affects you, definitely want to track that. There are also some new proposed labor regulations rules for agricultural employees that would permit card check for formation of a union, and that would require employers to provide additional information within specified timeframes when employees provide notice of an intent to organize. So again, if that's something that affects your business, definitely keep it on your radar. Next, there's a bill regarding businesses which have call centers in the state of California, and certain restrictions, including providing notice before relocating a call center to a foreign country, and then taking away certain state benefits from businesses that do relocate their call centers to other countries. Final thing to highlight is just a proposed expansion of some rules regarding remote work for finance lender employees. Basically, these employees were allowed to work remotely during the COVID-19 pandemic, and there's a proposed expansion of those rules that would essentially make it indefinite. So again, if this is something that affects you, definitely follow up, but we won't spend too much more time talking on them. All right, Tia, we've got 2 minutes for stalled bills.
All right, folks, we have some stalled bills. There are 10 of them that we were planning to go over, but I do want to be respectful of all of your time. So I am not going to cover them in any detail. I encourage you guys, once the slideshow is circulated to you, please take a look at those. And if any of them are of interest to you and you want to talk about them, reach out to me. I am happy to let you pick my brain. We can brainstorm. We just wanted them to be on your radar because as we see time and time again, the fact that a bill is stalled does not mean it will not resurface with a new name and a new face down the line. So again, these may come up at a later date. The 10 that are at the end of the slide deck as stalled bills are dead for the year and remains to be seen whether they'll resurface at a later time.
Super. Does anyone have any other questions that they either want to put into the chat or take yourself off mute and ask us? All right, well, seeing nothing, I will just, we'll leave you with a little bit of information about resources for monitoring developments. As I said at the very beginning, we don't know whether all of these bills are going to pass, and if they do, whether they'll be amended before they pass. But we encourage you to continue monitoring. As you know, the law changes a lot in California pretty much every year. So one way you can do that is you can click on the link here when you get this presentation and sign up to receive our legislative updates. We send them out about once a month, and that way you can keep on top of everything that is going on in California, the California legislature. If you want to go straight to the source, you can go to the click on this link and it'll take you to the California legislature. And then there's also the National Conference of State Legislatures, which can provide additional information about all of the states, not just California. And Audrey will send you guys the certificate for the CLE after today's presentation, and we'll also circulate this PowerPoint, which I hope is a useful resource to all of you. And again, please feel free to reach out to either me or Tia if any questions occur to you after the fact, and we'd be happy to try to help you out. Thanks, Audrey. I think that's it for us.
Thank you all for being here. I appreciate it.